Welcome to the Point. Welcome, friends. This episode of To the Point is on behalf of the Harborview Fellowship Elders. This episode's been a team effort, with every elder researching and working to understand the current state of affairs related to the new law that's in our state that has emerged out of ESHB 1531. On Tuesday evening, September 30th, we gathered together to discuss something critical, something that strikes at the heart of our families, our faith, and our freedom, and something that will have lasting ramifications. Our meeting focused on the bill ESHB 1531 and the bill that was signed into law by Washington State's Governor Bob Ferguson. We've spent weeks in prayer, consulting experts, and seeking truth. What we've discovered has made us uncomfortable, principally due to the potential for how this law could, in practice, be interpreted and implemented. As elders, we take seriously our responsibility to protect, to provide, and to guide in spiritual matters, and how those matters affect us physically and practically. Therefore, we conducted this research and its practical ramifications and how it can affect our lives together as a team. We are not attorneys, we're not medical doctors, nor are we financial advisors. Therefore, we're not providing legal, medical, or financial advice. And since we're not experts in the fields previously mentioned, we sought counsel from experts, such as, number one, a constitutional attorney in Seattle, who was the former attorney in the governor's office when Dan Evans was governor. He subsequently has formed his own firm, and he was also our legal advice when we filed our lawsuit against the governor a few years ago. Secondly, we consulted with the United States Attorney for the Eastern District of Washington, who was recently appointed by the Trump administration to that position. Thirdly, we talked with legislators, one of whom is an attorney and the current chair of the Washington State Republican Party and a former Washington State representative. We also interacted with Dr. Robert Malone, who's now the co-chair of the Advisory Committee on Immunization Practices, which advises the Centers for Disease Control and Prevention on immunizations and vaccinations. We also carefully examined the U.S. and Washington State constitutions, the Washington State Revised Code of Washington website, and the Washington State Department of Health website as well. And then finally, we looked at the analysis of this bill by the Conservative Ladies of Washington team. First, let's clarify what HB 1531 states. It requires state and local officials to implement and promote evidence-based measures to control the spread of communicable diseases, including immunizations and vaccines. It overrides any local laws or policies that conflict with these measures. Importantly, it includes an emergency clause, declaring it necessary for the immediate preservation for the public peace, health, and safety, and it therefore took effect the moment the governor signed it on April 21st of 2025. What does this mean to us in practice? It means the state now claims complete authority to educate us about vaccines, to implement health measures, and to mandate compliance. It means that if the state declares an emergency, something the state alone decides, it can enforce these measures immediately without debate, without recourse, and without regard for any personal objections. Based on this law, on September 4th, just last month, the Washington State Department of Health issued a standing order recommending COVID-19 vaccination for everyone 6 months of age and older. Currently, this is a recommendation. However, under the authority of this bill and now law, such a standing order could become a mandate. It is also important to understand what this signifies in light of the 10th Amendment to the U.S. Constitution. This was ratified on December 15, 1791, and the 10th Amendment states, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." Also, there's a Supreme Court precedent regarding state vaccine mandates. Specifically, in 1905, the U.S. Supreme Court decided its first vaccine-related case in Jacobson versus Massachusetts. The litigation posed the question, can a state enact a law making vaccination compulsory during a public health crisis? The question began in 1901 when a deadly smallpox epidemic ravaged the Northeast, prompting the Boston and Cambridge Boards of Health to order the vaccination of all residents. But some refused to get the shot, claiming the vaccine order violated their liberties under the Constitution. One of those holdouts, a Swedish-born pastor named Henning Jacobson, took his anti-vaccine mandate crusade to the Supreme Court. The nation's top justices issued their landmark ruling in 1905. By a clear majority, they legitimized the authority of states to reasonably infringe upon personal freedoms during a public health crisis by issuing a fine to those who refused vaccination. In our own state, it's important to also consider the context in which ESHB 1531 was passed and signed into law. When we examine the larger picture, we are able to observe that 1351 is the latest law in a decade-long legislative process that's had the cumulative effect of reducing parents' rights, and in so doing has transferred more and more power to the state government. Let's review the timeline. In 2017, HB 1661 enabled the state to regulate early childhood education, resulting in the systematic closure of Christian daycares under stringent regulations, which were replaced by corporate entities aligned with the state's agendas. In 2018, SB 5598 redefined parent and relative, which had the effect of weakening the parental jurisdiction. SB 5722 banned so-called conversion therapy, which, by the way, would be a therapy we would understand by counseling people to be able to live according to how God's Word and God's ways have been defined and described. Well, it effectively criminalized such counseling for children struggling with their gender confusion. HB 1874 prevented parents from accessing medical records of children aged 13 and older without the child's express permission. In 2020, COVID-19 emergency declarations shut down churches, closed schools, and imposed mandates. In 2023, HB 1469 permitted gender transitioning procedures and abortions without requiring prior parental notification. When the citizens of Washington State passed Initiative 2081, referred to as the Parental Bill of Rights, the state legislature and governor then subsequently overturned it with legislation that vacated the content and the intent of the original initiative passed by the citizens. Currently, in real time, schools are implementing policies, a number of which exclude parents entirely. For example, the Peninsula School District's manual now states that before contacting parents, school staff must consult with the student about their preferences regarding family involvement and consider safety concerns. In practice, this means a child, any child, even a first grader, can decide whether their parents are involved in their healthcare decisions regarding their gender. For transgender or gender-expansive students, the policy advises staff to ask the child how to refer to them when speaking with parents, implying that parental involvement might be dangerous. This is a clear example of the state replacing the role of the child's parents. Of particular concern is how fast these measures have been implemented, as seen by the following timeline. There's a graph that illustrates the trajectory of state measures regarding the limiting and the restriction of parental responsibility over their children, and it paints a picture that raises significant concerns for us. As you can see, there's been a steady trend that's increasingly diminished parental rights and our God-given rights of autonomy. If the prior trend continues going forward into time, the trend will not improve without an intervention from God. How is this possible? Well, remember, legally, the state relies on two key principles. The 10th Amendment, which reserves powers not assigned to the federal government to the states, and the 1905 Supreme Court case, Jacobson versus Massachusetts, which upheld state authority regarding vaccines during a public health crisis. Our state constitution's Religious Freedom Clause is also being misinterpreted. It guarantees freedom of conscience, but states that this cannot be used to justify practices that conflict with the peace and safety of the state. The state leaders could argue that state mandates override personal religious beliefs due to the need to protect public safety. ESHB 1531 is also empowered by prior laws that were passed which define and determine who can provide informed consent on behalf of children. RCW 7.70.065 defines who can give informed consent on behalf of children. This naturally includes parents, guardians, and individuals appointed by the court. However, in certain situations, others, such as school nurses, school counselor, or homeless student liaison, may also provide informed consent on behalf of a minor child. This applies to non-emergency, outpatient, and primary care services, including physical exams, vision tests and glasses, dental exams, hearing tests and hearing aids, immunizations, and treatments for illnesses and conditions, and routine follow-up care provided by a health care provider in an outpatient setting. This is excluding elective surgeries, but also includes mental health services, which can include gender care. And so as you can see, the context has been set. According to this law, any such persons who provide consent are not subject to administrative sanctions or civil damages. In summary, our research has left us as leaders with a strong resolve to encourage parents and grandparents to remain actively involved in all aspects of our children's lives, in school, health care, daycare, and any setting where their health and welfare could be compromised by persons without the knowledge or permission of the child's parents. In our next episode, we will delineate practical steps for us to take in light of these current events that we're in the midst of.